So, good afternoon, and on behalf of the Canadian Council of Muslim Women, welcome to CCMW's Domestic Contracts webinar. We do have people trickling in, but we are going to go ahead and get started, and hopefully people can catch up as they join us. We are now going to get into some housekeeping guidelines. So again, thank you for taking the time to join us today. My name is Sabrine Azrak, and I will be your moderator for the duration of this webinar. Before we begin the webinar, we just want to get through some housekeeping rules. So today's webinar is being recorded. The recording of this webinar will be available afterwards on our website and our YouTube channel. Our website is www.ccmw.com. The webinars before this have not been uploaded yet, but they all will be in due time. So we welcome each of you to revisit the content yourself and to share it with your networks. Please ensure that your video camera and your microphone are turned off during the webinar. This will help eliminate ambient noise and increase clarity and connection for the rest of the participants. We also invite your comments and questions as they're very important to us. So we will run a live Q&A session at the end of the webinar using the chat box. And the chat box is the sixth button from the left at the bottom of your screen. So once you click it, the chat box will then appear on the right-hand side of your screen. And if you think of a question at any point during the webinar, just type it into the chat box and I will collect those questions and pose them during the Q&A portion. You could choose to ask the question anonymously by sending the message to myself. So it will read Sabrine, the host, or you can choose to send the message publicly, whereas you would send the message to everyone. An evaluation will be emailed to you later today. It will take about 5 minutes to complete, and please do not include your name on this form in order to maintain your privacy. And the information that you provide will be kept confidential and private, and only authorized individuals at CCMW will have access. Our last point is that if you have any technological assistance or if you require any tech support at any time, please send me a direct message using the chat box, or you can send me a text message at 416-897-1907. I'll write that number in the chat box for you as well. And we are going to get to the vision and mission of CCMW. So the Canadian Council of Muslim Women is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in both English and French, as well as a series of booklets in several languages on family law topics to further our public education efforts. Our latest project in this field is titled Muslim Women's Family Law and Legal Rights Project. And in this project, we updated these documents and disseminated them via knowledge sharing workshops within different cities across Canada for Muslim women, community service providers, the legal profession, and the general public. A point to be taken here is that the knowledge sharing workshops were put to a halt because of COVID-19, and these webinars are really helping us share this knowledge in a way that is virtual and essentially safe. In 2003, CCMW took the lead in establishing a coalition against religious arbitration, composed of over 50 sister organizations, including the National Association of Women in the Law, METRAC, and the WYCA, or the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, as well as 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, please visit www.ccmw.com. I am now going to turn it over to Pamela Cross, the facilitator for today's webinar.
Thank you very much, Sabrine. And let me add my welcome to all of you and thanks to all of you for joining us this afternoon for this webinar, which is produced by the Canadian Council of Muslim Women. I'm a lawyer and I've worked with CCMW on a number of projects over the past several years. The focus of the work I do with a variety of different organizations across the country is on violence against women and the law. I also want to welcome Professor Omar Farhat, who is joining us, as he did last week, for the discussion that we'll be having at the end of this webinar, although I may pop a couple questions to him as we go through the webinar presentation itself. And I believe he'll be with us for the next two webinars as well. It's my honor to be facilitating this series of 7 webinars, which reflect the content in 6 brochures produced by CCMW that provide comparative information about Canadian and Muslim family laws, particularly as they pertain to women's rights. The topics covered in the brochures are marriage, divorce, custody and child support, family property and spousal support, domestic contracts, which is what we're talking about today, and inheritance. The goal of the written materials, as well as these webinars, is to assist Canadian Muslim women in being able to make informed choices in the area of family law in Canada. We hope these resources will also be of assistance to professionals who work with Muslim women in the family court system, students who would like to know more about these issues, and community-based services that assist women. These are the covers of the brochures that I mentioned a minute ago. All of them are available on the CCMW website. The content of both those brochures and these webinars comes from Muslim and Canadian Family Laws, a comparative primer that was published by CCMW in 2006. And the content from that primer that's contained in the brochures and that you will hear in the webinar today, as in all of the other webinars in this series, was updated in 2019 to reflect changes in the law that have happened between 2006 and now. Please note that the information contained in these webinars is just that, it's information. It is not legal advice, and it should not be interpreted as such. If you or someone you know is dealing with a family law issue, it's important for them to meet with a lawyer, to discuss the situation, to share all of the facts that are relevant, and then to receive legal advice. Only a lawyer who is licensed and who is insured and who has all of the relevant facts can provide legal advice. The webinars, the brochures, and the primer, while we hope they are helpful to you, are not a replacement for legal advice. They're a starting point to provide you with enough general information that you know what legal advice you might need or what legal issues you're dealing with. If you want to find out about the sources and validity of Muslim laws and legal opinions that are referred to in these webinars, we encourage you to consult Muslim and Canadian Family Laws, a comparative primer. Laws in a public legal system like Canada's are in a constant state of flux. They change to adapt to the times. We've seen this recently. The Divorce Act underwent its first round of significant revisions since the mid-80s last year, and in March of 2021, those changes will come into effect. What you hear in this webinar and what you read in the brochures is accurate to the date In the case of the webinar, the date it was recorded, and in the case of the brochures, the date they were published. You're encouraged to verify that the information contained either in the documents or in the webinar about Canadian laws is current at the time you are reading it or hearing it. At the end of my presentation, which will take 30 to 40 minutes, we'll have time for questions and answers. As Sabrine has said, you can pose your questions by writing them into the chat area on your computer screen. And do that at any time. Don't wait till the end because you might forget the question. So jot your question down in the chat area at any time. And then at the end of my presentation, Sabrine will read the questions out so everyone can hear them. And Omar and I will do our best to answer them. Let's move on to the topic for today, and that is domestic contracts. In classical Muslim doctrine, marriage is a contract entered into by the bride and the groom, sometimes through their guardians. And we talked a little bit about the role of guardians in the very first webinar of this series, the one on marriage. So if you weren't able to attend that webinar, or if you've forgotten what we talked about that day, as Sabrine has said, the webinar will be posted shortly on the CCMW website, and you can revisit it. So the marriage itself is a contract in classical Muslim doctrine. A domestic contract that regulates some aspects of marriage in Muslim law may include conditions as an addition to the standard contract of marriage. The fundamental guiding principle in Muslim law is that any contractual conditions mutually agreed upon between the parties are valid on two provisions. First, that the conditions are not in violation of clear divine injunctions. And secondly, that the conditions don't defeat the purpose of the contract of marriage itself. So that makes sense. You don't want to put conditions in your marriage contract or your domestic contract that defeat the purpose of getting married itself. All the classical schools have agreed that the bride, and less frequently the groom, and her guardian are entitled to include some conditions in the marriage contract. There's some disagreement about the degree to which the husband is bound by such conditions, which conditions are valid and which are not, and the consequences of including an invalid condition in the contract. Some have held that conditions included in the marriage contract that are not otherwise invalid are obligatory upon the husband. In other words, if it's a valid condition, then the husband has to follow it. Others say that respecting these conditions is only recommended, but not mandatory. And others have said that husbands are under no obligation to satisfy any conditions other than those that follow from the marriage relationship by force of law, such as his obligation to provide financial support. And we talked about that obligation in last week's webinar, where we were talking about spousal support, maintenance, and division of property. Because most Muslim majority states have now adopted modern legal systems in which mutually agreed contracts are binding, valid conditions included in marriage contracts will be enforceable in those legal systems. In Canada, provincial and territorial legislation, not federal legislation, governs what kinds of private contracts individuals can make to set their own terms for their relationship or the end of their relationship. In Ontario, cohabitation agreements, marriage contracts, and separation agreements are all considered to be domestic contracts and are governed by the Family Law Act, or the FLA. A cohabitation agreement, a marriage contract, which is sometimes called a prenup, those are agreements or contracts that the parties enter into at the beginning of or during their relationship. And obviously, a separation agreement is the agreement that a couple may write if they're able to negotiate their differences at the end of the relationship. Ideally, both a cohab agreement and a marriage contract would be written at the beginning of the relationship, but they can in fact be written at any time during it. And we'll talk later about what makes one of these agreements or contracts valid and enforceable under law. Domestic contracts in Canada can cover many aspects of a couple's relationship, but in particular, cohabitation agreements, marriage contracts, or prenups mostly focus on financial and property matters. Traditional scholars divided the issues in a marriage contract into three categories with respect to their validity: those that are valid, those that are invalid but do not invalidate the marriage itself, and those that invalidate the marriage. There's some disagreement among different schools about what makes a contract valid. Some schools accept the validity as long as the subjects in a contract do not defeat the purpose of marriage and hold that those conditions are binding on the husband. Others tend to believe that only topics intrinsic to the contract of marriage need to be followed and no further topics need to be included. Conditions that are commonly seen as valid include the woman's right to work, financial support for continued studies, the right for the woman to remain in her town or her country, and her right to live in a household of her own. Many scholars have also accepted as valid a clause setting out the wife's right to demand that her husband not take another wife, that also stipulates the marriage contract would be dissolved if he were to do so. Many have also validated clauses that provide a certain amount of time after the marriage ceremony before sexual relations can begin. And here's where I have a question for Omar. When I looked at these notes last night, I thought I could read that sentence a couple of different ways. So does that clause mean that sexual relations are not permitted to begin for a certain amount of time after the marriage ceremony? Or does it mean that if sexual relations don't begin within that time, the marriage becomes invalid?
This clause, the way I think the intention or the clause that we had in mind in referring to in the brochure was that it would be permitted not to enter into, because sexual relations, as I'm sure you've discussed, is an implied, not implied, is a fairly fundamental condition of the marriage contract. So the intention here is to say the contract itself is valid, but it's both parties agree that they will not enter into sexual relations for a particular duration of time, and no party will because, as you know, this could lead to conflict and could be one of the reasons. We'll talk about dissolution and divorce in another webinar, I believe. But this is one important source of conflict. So this was, I think, this was a clause that was particularly common in previous times before modern laws, when some types of marriage arrangements were kind of like a promise to marry, especially when the age of the parties was little. So then the contract would be a promise to marry, basically, but saying that the bride and groom will not join together in the same household until a certain point in time or until a certain age or something of that sort. Of course, these conditions are not that common now because all Muslim majority states have a minimal age for marriage. But yes, this is what we had in mind. The other reading is yes, I agree, is possible as well. But that would saying that if within a certain amount of time no sexual relations occur, what will happen to the marriage? This is already regulated. So there are rules having to do with withholding sex or a missing husband. And what will happen to the marriage contract in those situations. But it is possible to have a condition of that sort. It will be basically a condition about the right to dissolve the contract. As you've mentioned, it's very possible, and it's actually quite common until today for the husband to agree in a condition at the time of concluding the contract to say that the wife will receive the right to unilaterally end the contract. So this would be one aspect of the solution, I think. So to my mind, this would be a question of dissolution in case sexual relations are not occurring in the way the parties or the law intended them to occur. But yes, the intention here was we were talking about postponement, basically, of living together as husband and wife.
Great. That's really helpful. Thank you, Omar. As I mentioned a few minutes ago, there are some clauses that could be put in a domestic contract that would be found to be invalid. For example, clauses that are illegal or incompatible with the purpose of marriage. And this goes back to what Omar was just talking about, such as a condition to withhold sex indefinitely, or to divorce an existing wife, or for the wife to live away from her husband's domicile. So those clauses would be seen as invalid, but according to the scholars, they would not invalidate the marriage contract. It's just the clauses that themselves would be seen as invalid. There are a few clauses that would invalidate the marriage altogether. For example, term limits, making the marriage a temporary one, or any marriage that sets out in it a clause that there's an intention to get divorced. A husband could also include clauses in a marriage contract, but they cannot contradict his basic obligations to support his wife and children financially. Therefore, clauses that attempt to shift the financial burden from the man to the woman would be found to be invalid. In Canadian law, not everything can be addressed in every domestic contract. Ontario's Family Law Act, like legislation in other jurisdictions in Canada, specifically excludes post-separation parenting from being governed in a marriage contract or cohabitation agreement. And this is because, as we talked about in the webinar about child custody, decisions about arrangements for children are to be made based on the best interests of the child. It's impossible to anticipate at the beginning of a marriage or a common law relationship what the best interests of those children might be. The children are probably not even born yet. The couple may not even have decided whether they're going to have children. If they're married for 15, 20, 25 years, the children will be adults, presumably, at the time the parents separate, and so there wouldn't need to be any custody arrangements made for them at all. So a marriage contract or a cohabitation agreement cannot speak to the issue of who will have care for the children if and when the parents ever separate. A separation agreement, on the other hand, which is another form of domestic contract, could indeed set out the parenting arrangements for the children, because it's being written after the parents have separated, at which time the best interests of the children can be determined. Ontario law also states that any provision in a marriage contract that limits one spouse's or partner's possessory rights to the matrimonial home is unenforceable. Now, this is very different from the property rights, which we talked about last week. This is about possessory rights. In other words, if I were writing a marriage contract with my soon-to-be spouse, it could not say that if our marriage comes to an end, if we decide to separate, I must leave or my spouse must leave the matrimonial home. More generally, courts can disregard any provisions that are not in the best interest of the child, that are unreasonable with respect to child support, that make the rights of either party dependent upon their remaining chaste, in other words, not having sex, or prevent the remarriage of either party. So you can't, in a marriage contract, a cohabitation agreement, or a separation agreement, set out that one spouse would only pay spousal support to the other for as long as that spouse remained chaste, or that one spouse would say that the other spouse could never remarry. Also, upon application to the court can set aside a domestic contract or parts of the contract if either party failed to disclose significant assets, debts, and liabilities. if a party did not understand the nature or consequences of the contract, or if the contract is not in accordance with the law. To be valid, a domestic contract must include a certificate or waiver of independent legal advice to ensure that the person understands the contract and is not signing it under coercion. I want to take just a minute and give you examples of each of those kinds of situations. It's not easy for a court to set aside a domestic contract because the law of Canada firmly believes that adults have the right to contract out of their legal rights and responsibilities if they follow the rules. And so here, as I've just said, a court could set a contract aside if somebody failed to disclose assets, if they coerced the other person into trying to sign it, if one of the people signing the contract didn't understand it. What would that look like? Well, for instance, if a newcomer woman to Canada who still doesn't speak English or speaks only very limited English were to be presented with a marriage contract prepared by her husband-to-be or his lawyer, written in English without any opportunity to have it translated for her, there's a good chance, if she signed it, there's a good chance that she would be able to have it set aside later on the basis that she didn't understand what was in it. If two people sign a marriage contract and then sometime later one of them discovers that the other had vast pots of money or debt that they failed to share when the contract was being signed, that can be the basis to have the contract or parts of it set aside. Or if there's coercion, and coercion can happen in a few different ways. Let's say that the two people getting married are new to Canada, they still have family members elsewhere in the world, and one about-to-be spouse says to the other, here's a marriage contract, either you sign it or my family will make life very difficult for your family. That's coercion. If it's the day before the wedding, there's been no talk about the possibility of a marriage contract, and suddenly one of the people presents to the other a marriage contract and says, you have to sign this or the wedding tomorrow isn't going to happen. That's a form of coercion. It could also be seen as duress. In either event, if the person who's unhappily signing the contract wants to take that to court at a later date to say that this contract shouldn't be valid, they would probably have the basis to do that. Since domestic contracts, as I've just said, allow people to sign away their legal rights, it's important that both people seek independent legal advice before signing a marriage contract or a cohabitation agreement, or at the end of the relationship, a separation agreement. Even if terms in the agreement are unfair to one person or the other, or even if they are different from what the law would provide, once that contract has been signed, the courts cannot intervene and set it aside unless one of the people did not provide full financial disclosure or the contract was signed under coercion or duress. Independent legal advice means two separate lawyers. It's not independent legal advice if one of the spouses has their family lawyer prepare the marriage contract, and then that same lawyer reviews it with the soon-to-be other spouse, because that lawyer's vested interest is in supporting the rights of the person who's hired them. And so the other person isn't necessarily going to be getting legal advice that's independent and that is focused on them. So just a couple of examples of what could be in these different kinds of contracts. In a marriage contract, where, as you know from previous webinars, the law in Canada says that all of the property is shared equally between the two people if the marriage ends, the two people could set a marriage contract that said, no, we don't wish to share our property equally. In fact, each of us will keep what we brought into the marriage, including the matrimonial home, which spouse A owned prior to the date of marriage. Spouse A retains the financial interest in that property and isn't obliged to share any of the value of that property or pensions or art, antiques, anything. It doesn't matter what. But a marriage contract could set that out. The marriage contract could also stipulate that neither spouse will pay spousal support to the other. should the marriage end. Cohabitation agreement, because the division of property is very different, and unless you're married, there's no statutory right to share equally in the value of the property. Cohabitation agreement could say, we do wish to share our property equally if our relationship ever ends. It doesn't matter whose name is on the deed, whose name is on the ownership papers to the car, the boat, whatever it might be. If we separate, if we end our relationship, we want to share the value of everything that we have equally, or 60-40, 70-30, whatever it might be. So you can see that in those two kinds of contracts that people sign at the beginning of their relationship or early on in their relationship, they're anticipating how they might want to sort out financial concerns at the end of the relationship. Separation agreement can cover both of those issues. It will set out how property is to be divided, how spousal support is to be prepared. A separation agreement can also speak to child support, but it has to at least meet the standards of the child support guidelines in effect in Canada. So while one adult can give up their right to spousal support if they wish to, or can accept a lower level of spousal support than the law would have given them, the law in Canada does not let a parent sign away child support because that is seen as in the interest of the child. Having said that, there are rare exceptions, and I'll give you just a very extreme example to make my point simple. If I have an income of $3 million a year in a very secure job, I can't imagine what that job would be, but anyway, let's pretend that I have that job and I make $3 million a year. And my spouse or my common law partner has a job in which they make $10,000 a year. The court might accept an arrangement in which my now former spouse does not pay child support because my income is so exorbitantly high. And the amount of child support that my ex, who's only making $10,000 a year, would ever be able to provide would be minuscule compared to the amount of income that I have. But generally speaking, child support has to follow what the law of the country says, as opposed to what people put into a separation agreement. One thing that cannot be dealt with in any of these kinds of contracts is a restraining order. So a separation agreement cannot include a restraining order. It's an order. It has to come from the court and only from the court. Like all matters relating to Muslim contracts under a modern state, the authority to enforce the contract will depend either on the parties, a designated arbitrator, or the state within which the parties live, if the contract follows the rules and forms required by that state. If there is no centralized Muslim authority, it's up to the parties to identify a competent person or authority to assist them in managing any disagreements that might arise. Alternatively, the parties should ensure that their domestic contract meets the legal requirements to be enforceable in the jurisdiction where it's been written. To be enforceable in Ontario, a domestic contract, whether that's a marriage contract or a cohabitation or separation agreement, must meet the requirements set out in the Family Law Act, which we've discussed earlier. The same is true in the other provinces and territories. Provincial and territorial legislation also sets out how domestic contracts made outside that jurisdiction are to be handled under the laws of that jurisdiction. So in Ontario, a domestic contract is valid regardless of where it was made, as long as it is in accordance with Ontario law, and as long as it is not what the law calls unconscionable. That goes back to what I spoke about a few minutes ago in terms of lack of proper financial disclosure, duress, or coercion. To ensure enforceability of a Muslim domestic contract, it should be drawn up according to the terms set out in the family law of the province or territory where it's being written. Anyone preparing a domestic contract should work with a lawyer who's knowledgeable about family law in their province or territory to ensure that it meets all of the required elements. A Muslim woman entering into a domestic contract should keep in mind that Muslim laws widely invalidate any condition that gives away a woman's natural rights under a marriage contract. Such natural rights include her right to full financial support by her husband, the right to her dower and her own financial independence, the right to travel to see her family, and the right to perform religious duties. None of those rights can be surrendered by the wife from the standpoint of Muslim law. Either party can approach the court to enforce a domestic contract under Canadian law. In other words, if I've signed a domestic contract and I feel that it's now unfair to me because my partner didn't provide me with full financial disclosure, or I didn't have a chance to read it before I signed it, then I can go to the court and say, I want you to find this contract invalid and unenforceable. Or I could go to court and say, look, I have a marriage contract here and my ex-spouse is not following it. In it, it says that my ex-spouse is to provide me with $50,000 by such and such a date. They failed to do that, and so I'm asking the court to enforce it. Go to the court to say, don't enforce it because it should be an invalid contract, or you go to court and argue that it is a valid contract and the court should assist in having it enforced. So maybe we can get muted there. Somebody doesn't find this a very enjoyable topic. To be enforceable, again, under Canadian law, a domestic contract must conform to the requirements contained in the relevant provincial or territorial legislation. In most cases, this means there must have been full financial disclosure by both parties. The contract must be in writing. It must be signed by both parties. Their signatures must be witnessed, and the contract cannot have been signed under duress or coercion. The witnesses don't have to read the contract. All they are witnessing is the signatures. So if you're involved in writing a domestic contract and you're looking for witnesses, but you don't really want them to see your private business, just like when you write a will, they don't have to see it. In fact, they shouldn't see it necessarily. That's a matter of choice. The witness is to your signature. So they have to be present when you sign it, they watch you sign it, and then they sign that they watched you sign it. While it's not mandatory in all Canadian jurisdictions, it is strongly recommended that both parties obtain independent legal advice before signing the contract. As I've mentioned before, even if a component in the contract is unfair, with the exception of certain invalid conditions that I've already mentioned, the courts are bound to uphold the contract unless the above form and process requirements have not been met. Courts generally give great deference to domestic contracts, taking the position that competent adults should be free to set the terms of their own relationships, and they only intervene in extreme circumstances to set those contracts aside. The Supreme Court of Canada has ruled that adults are free to sign away their legal rights, and that they must assume responsibility when they do so, even if the consequences prove to be negative. And because the Supreme Court has made that decision, all other courts are bound by it. This principle does not necessarily reflect the interests of vulnerable people. For example, women with abusive husbands, women who are newcomers to Canada and may be unaware of their legal rights here, or women who are coerced by their communities into signing private agreements without benefit of proper legal information and advice. And there certainly are some powerful cases that speak to this in a variety of different contexts. I'm thinking of one where a woman who came from quite a modest background was marrying a man who was extremely wealthy. He had never discussed with her the possibility of a marriage contract, and literally the day before the wedding, so the flowers have arrived, the dress has been bought, the guests are on their way, he presented her with a marriage contract that was very complicated. It was many, many pages long. It had many complicated clauses in it about the financial arrangements between this man and his family. And he said to her, either you sign this today or I'm calling off the wedding. That's coercion, that's duress, because what's she to do? She wants to marry the man. She wants to believe that the marriage contract is fair to her. And then there's the kind of embarrassment factor. All these people are about to show up to watch them get married. So she signed it. And some years later, they separated. And she looked back at the marriage contract and realized that it was grossly unfair, that she, in fact, hadn't understood it when she signed it. In that case, the court did say that the marriage contract would be set aside and that they would be dividing the property and sorting out spousal support according to the laws of Canada. There's other cases where, and I mentioned this a few minutes ago, where one of the parties didn't speak the language in which the contract was written. They weren't given an opportunity to have it translated before they had to sign it. A number of cases where, I'm sorry to say, it seems to almost always be the husband. A number of cases where the husband had used a family lawyer, a lawyer who had done business, had been the lawyer for the family business, to write the marriage contract, and then told the wife-to-be that she had to meet with that lawyer for so-called independent legal advice. So it's not as though these contracts are never overturned, but it's a narrow set of parameters within which a contract can be overturned, because the courts believe that competent adults should be free to set the terms of their own relationships. And generally, that's a good thing. But in situations where women are vulnerable, where people are vulnerable, in particular women, that attitude isn't always helpful. I want to talk a little bit about the mahar, and I'm sure that there will be many comments and questions about this when we get to the discussion in a few minutes. Whoops, I didn't mean to get to the discussion quite that quickly. Hold on a second. Canadian courts will enforce a mahar if it has been properly prepared and meets the standards of any other domestic contract according to the relevant provincial or territorial legislation. In other words, if a mahar looks like a domestic contract, if it has been, if it's written, if it's been signed by both parties, if the signatures have been witnessed, if there's no evidence that there's been a lack of financial disclosure, if there's no evidence of duress or coercion, a mahar will be viewed as a domestic contract, and then it will be enforced as if it were a domestic contract. The more specific and detailed the mahar is about the amount, the timing, and the circumstances in which the mahar is to be provided to the wife, the better, because then it looks like a domestic contract. It's also important to understand that in Canada, the mahar does not replace spousal or child support, and it does not form part of the wife's family property. So she can have the mahar and also has a right to share in the value of the family property. We're talking here about people who are actually married to each other, because as you'll remember from last week's webinar, people who are not married to each other don't have a right to share in property. There are a number of cases on this point now in Canada. I'd say in the last 10 years, there have been a significant number of cases, and this is the overarching position of Canadian courts, that this is not a private and religious document, but rather, if it's properly written, it is a domestic contract. So that brings me to the end of what I was going to talk about today. Let's turn it over to Sabrine for questions, and also certainly, in addition to Omar answering questions, if you want to add anything to the content of what I've shared, please jump in. Sabrine, over to you.
Thank you very much, Pamela, for the excellent facilitation. So I've received 2 questions thus far. The first question is, if an imam writes an Islamic marriage contract with valid conditions, does this contract have any weight in a court of Canadian law? If so, are such conditions enforceable, and how?
Well, I'll take one kick at that, but Omar, you may have some comments as well. If the contract prepared by the imam meets the requirements of a Canadian domestic contract, so that would be dependent on what province the people were in, because those laws are provincial, not federal, it would be seen as a marriage contract. And so if somewhere further down the road the people separate, either of them could turn to the court to ask for enforcement if the other party wasn't following it. Would it be registered with the marriage? I don't believe so, because typically these contracts aren't registered with the marriage itself. So this is going a little bit more broad than the question itself. If I write a cohabitation agreement with my common law partner or a marriage contract with my spouse, I probably just stick that in a filing cabinet and I forget about it, because I'm assuming we're never going to split up. And if we split up, my partner's going to treat me really well, all of that kind of stuff. Then we do split up and I realize, oh, geez, things have gone a little sour here and my spouse is not going to follow this contract. Then I haul it out of the filing cabinet. I march down to the family court and I have it registered as an official document at that point, and then it becomes enforceable by the courts. So it wouldn't really matter who wrote that contract. That's the process that people would have to go through. But as with any domestic contract, it has to meet the requirements of form. It has to be in writing, has to be signed, has to be witnessed. There can't have been duress or coercion, and there has to have been full financial disclosure. So if the imam isn't making sure of all of those elements, then it's possible there's a contract where there might be a moral obligation on the people to follow it, but possibly not an obligation under Canadian law. It's the form that really matters here. So Omar, I don't know if you have anything to say in addition to that in terms of how an imam might.
No, not much to add, except it's important to be careful that the importance of the form is not the same from the perspective of Islamic law. So just because the imam said that these conditions, it could satisfy the conditions of validity from the perspective of Islamic law, but still not be enforceable. Especially, that the classical doctrines don't stress writing that much. They rather stress the consent of both parties and the fact that the fundamental kind of essence of marriage has been respected in setting out the conditions. So it's very important to be careful to satisfy the formal conditions that you mentioned to make sure that the contract is enforceable from a Canadian perspective.
It's also possible, and I don't want by saying this to leave the impression that the form doesn't matter. The form matters a great deal, and the law is a useful tool in making sure that people do what they're supposed to do in situations where the contract has been properly written, or properly written, meaning according to the law of the province or territory where it was written. But it's also the case that sometimes there are other ways to make people do the right thing, by which I don't mean you get a baseball bat and go over to their house at all. But if the couple here that has a marriage contract prepared by family member, an imam, a leader of the community, that doesn't meet the formal requirements under the law of the province where they're living, it's quite possible that pressure from the community will ensure that people do the right thing, because none of us like to look bad to our family or friends. And so if I make an agreement with my spouse and then I become a jerk and I don't want to follow that agreement, if members of our family, members of our small community say to me, Pam, you were being a jerk. Like, if you don't do what you said in that marriage contract, we won't do business with you anymore. We won't invite you over for religious holidays. We won't include you in our community. In other words, I feel really nervous saying this because I'm not trying to suggest that it's okay just to have a very informal agreement and then you hope that your community will help you get it enforced. The goal here is for people to have domestic contracts that are enforceable under Canadian law. But I do just want to point out that there are other ways to persuade people to do the right thing in addition to the law.
Thank you, Pamela and Omar. The next question reads, if a husband disappears and does not support his wife monetarily, and he refuses to give her a divorce when she asks for it, how does this work? Does this invalidate the marriage contract? Also, if they haven't lived together for over 4 years or so, does this invalidate the marriage contract?
All right, I will answer that question under Canadian law, and I'll only answer it briefly because in next week we're going to talk about divorce in greater detail, but I think there's quite a different answer in terms of Muslim family law. So I'll go first and then Omar can follow. There isn't an automatic marriage contract under Canadian law. If two people get married, they're married, and what happens between them during that period of time is kind of their business. So there's no obligation of either spouse to support the other, as there is an obligation on the husband under Muslim law to provide maintenance to his wife during the marriage. There is no such obligation. So I'm married, I'm a jerk, I take off, I don't provide any support to my spouse or to our children, I disappear. There's not much that can be done about that, but eventually my spouse gets fed up with it and decides I want a divorce. It doesn't matter whether I consent or I object. There is a procedure to get a divorce, which we will discuss next week. And if my spouse goes through that procedure and makes every attempt to serve me with the documents, they'll be able to move ahead with a divorce, whether or not I agree to it. In fact, whether or not I ever even respond to her or his court documents. And that divorce could include an obligation, a financial obligation on me to provide support to the children. It could also set out how the family property will be divided, whether or not I agree with it. In Canada, and again, we'll talk more about this next week, people can divorce after they've lived separate and apart for a year, and they don't have to provide a reason. It's just called irreconcilable differences or irreconcilable marriage breakdown. Or if the person wants the divorce more quickly than that, and they can establish either adultery or undue cruelty, extreme cruelty, then they can have a divorce more quickly. And we will discuss next week what each of those categories means. So I hope that's helpful. But Omar, it's quite different, I think, under Muslim law in terms of abandonment and the marriage contract and so on. Am I right?
Yeah, I mean, as you said, we'll have another discussion about that. But briefly, yes, there is a big difference between whether it was the husband or the wife who took off, and between the husband stopping, not providing, and the husband disappearing. So, in terms of disappearance, there will be a process, assuming the wife doesn't have the right to end the marriage, which could be included as a precondition. Assume she doesn't have that right, a husband sort of not being around for an extended period of time, the court, she can request that a judge dissolve the marriage, and then there's all kinds of discussions about how long she should wait and so on, that we can get into in the future. But a husband being around and not providing, that's considered a major breach of the marriage contract under Islamic law. And there are lots of cases, in classical cases, where the husband's property was seized, and the husband went into got into a lot of trouble for failing to provide. So again, then the process would be to go to a judge and request that the property be seized, and from the proceeds of that, the spousal support would be paid. Some of these things were incorporated into modern Muslim majority nations' laws, but that was kind of the situation in a pre-modern law world.
Great. Thank you. Back to you, Sabrine.
Thank you both. The next question is, what do you mean by properly written?
I realize that was a really poor way for me to phrase that. By properly written, I simply mean that the domestic contract has to be written to meet the requirements of the law in whatever province or territory it's written. And generally, that includes these features that I've mentioned a few times: that it be in writing, that it be signed by both people, that their signatures be witnessed, that the people have provided full financial disclosure to one another, and that there's been no coercion or duress. There are some provinces, not Ontario, there are some provinces that also make it mandatory for each person to have had independent legal advice. So we highly recommend it, but if you live in Ontario, it's not actually a mandatory requirement.
Thank you kindly. The next question reads, what is the status of a nikah or nikah written by an imam that is not registered because one of the spouses is married to someone else?
And so I don't know whether this is a question about what's the status of the nikah under Canadian law or within Muslim law. And maybe, Omar, you could go first within Muslim law, and I also need someone to translate the word nikah to me. Is that contract?
Yeah, so that's the marriage contract. So
okay.
I understand in that situation, it was the husband was already married, and it was so an imam who was not registered concluded a second marriage with another woman. Is that right?
That's what it sounds like to me. Yeah.
I mean, from an Islamic law perspective, it would depend on, is it done in public? Does everybody know that that's going to happen, or is it so secret marriage is invalid under Islamic law, but there's no registration as such. So the imam not being registered wouldn't be a problem for an Islamic law perspective, and being a second marriage wouldn't also be a problem from the classical, the dominant classical doctrine allows it, even though some modern nations have restricted that. So the only issue here would be whether the conditions set out in classical doctrines are satisfied. Are they of age of capacity? Do they give informed consent? Is it public, and so on? Was there a mahr? But I suspect that the issue here is about Canadian law more. So I'll let them take it.
Here we've got a situation where that second marriage is not going to be recognized under Canadian law because, as we talked about in an earlier webinar, polygamy is not legal in Canada. It's a criminal offense, in fact. So it wouldn't really matter what the content of the nikah was. The marriage itself is not going to be recognized as legal. Both of the parties, the imam and anybody else who participated in that marriage ceremony, could be charged criminally under the criminal code legislation prohibiting polygamy, although as we did talk about in an earlier webinar, that almost never happens in Canada. But this second wife is not going to have much in the way of rights under Canadian law unless the subsequent marriage happened in a country where polygamy is legal, in which case, regardless of what the nikah says, if the family then comes to Canada and the subsequent wife leaves the spouse or the spouse leaves her, she may, under the laws of Ontario family law, be able to get some amount of spousal support and some amount of some share of the family property.
Thank you. The next question is, if in a domestic contract the wife agrees to not have any rights to the property in a time of divorce, but she gradually contributes to paying some costs, utilities, etc., how can that be counted in times of divorce?
Well, not very well from her perspective, for sure. If the domestic contract met all the rules, properly signed, no coercion, no duress, etc., then that's going to hold. And so if what the wife actually wants is to say, I only want to share in the value of the property with respect to what I contribute to it, that would need to be written into the domestic contract. And it could be written that way. So let's say it's a marriage contract and the wife is moving into a house that's already owned by the husband. It's worth $400,000 and it's paid for. And he wants to protect that for himself because he paid for it and doesn't think that his wife should get half of it. That's fine. They can say that in the marriage contract. It could also say that the value of the house on the date of marriage, $400,000, belongs 100% to the husband. But that they agree the wife can share in the increase in the value of the house generally. So let's say it's worth $500,000 when they separate, then they would share that $100,000. Or it could be more specific along the lines of the question. It could say that the wife can claim back anything she contributed towards the house. If she paid the utility bills, if she paid for having a new roof put on the house, if they put an addition on the house and she paid for that. But the contract would have to set that out. If it didn't, if the contract said that she was giving up her right to any claim against the value of the matrimonial home, then she's given up her right to that.
Thank you kindly. The next question reads, what happens if the conditions of a domestic contract are in direct conflict with equity around inheritance, child custody, and other laws? How does that play out?
Generally, a domestic contract, at least in the context of our conversation today, is not dealing with inheritance. It's dealing with what happens to the family law issues if the marriage or if the common law relationship comes to an end. Child custody can only be set out in a separation agreement. It cannot be part of a marriage contract or a cohabitation agreement, or if it is, it's not enforceable because the child custody issues can only be resolved at the time of separation, and they must reflect what's in the best interest of the child, which isn't related to equity. In other words, if my spouse and I separate and we write a separation agreement that says the children are going to live with me and they will only see their father twice a year, it's not very equitable for the father. But as long as that's in the best interest of the children, that's fine. If it's not, then their father would have to take me to court and say this separation agreement is not in the best interests of the children. It's not about what's fair to either of the parents. It's about what's in the best interest of the child.
Thank you. The next question is, some people go back home and do marriages back home and not register them here. What about that contract?
If the marriage happened in accordance with the law of the country where it took place, and then the person moves to Canada or comes back to Canada, first, as we've already talked about in a previous webinar, the marriage is considered legal here. The people can divorce here, but the marriage contract, if that's what's meant by the word contract here, the marriage contract is not written in a way that follows the law of the province, then it's not going to be enforceable. So if it's a contract that met the requirements of the country where the marriage took place, but doesn't meet the requirements of Manitoba, let's say, if that's where the people are living, then it's not enforceable in Manitoba.
Thank you, Pamela. The next question is, what if a couple did an Islamic marriage contract with an imam that did have a proper form as a domestic contract, but they did not register their marriage as a civil marriage? Would the Islamic marriage contract be enforceable even though they are not married according to civil law?
Probably. It would probably be enforceable as a domestic contract if it met, as the person asking the question has said, the formal requirements of the law with respect to domestic contracts in that province. So they may not be legally married under civil law. They may not be able to get a divorce, but the marriage contract, and I'll put quotation marks around that, could stand as a domestic contract, even if they're not married.
Thank you. The next question is, if separation is due to infidelity by the man, can the wife seek compensation for harm caused by violation of the Islamic commitments made in the marriage contract? How will a Canadian judge view such a claim?
Canadian laws are not that interested in infidelity. and we'll talk more about this when we talk about divorce next week, but I'm not going to be able to get financial or material compensation because my spouse was unfaithful to me. That's just not the way marriage and divorce are understood in Canada under civil law. Certainly, as we'll discuss next week, if there's been infidelity that I have not forgiven, then I can use that as a basis to get a divorce more quickly, but it's not going to get me more money or a bigger share of the family property.
Thank you, Pamela. The next question is, what if the first wife agrees to share assets with the second wife and the second wife is in Canada as well?
So I'm assuming that question goes back to the earlier question.
I think.
I would say that would have to be some kind of a private arrangement. It's not something that I think the Canadian family courts would get themselves involved with, because it's, first of all, a polygamous marriage, which isn't recognized under Canadian law. But if they just wanted to, between them, say that's what they were going to do, certainly they're free to do that. I just don't think that, I could be wrong, but I don't think they're going to get very far if they turn to a court to help them sort that out somewhere down the road.
Okay, thank you. And what looks like the last question is, if the wife resides in Canada and has no children and her husband is back home, if she were to die here, who will get her property?
Well, let's save that question for next week when we're going to talk about inheritance.
Okay. If anybody else has any questions, if you want to add them to the chat box immediately. If not, I think we can just continue on to the evaluations. Okay, so thank you to each of you for participating in this webinar. Thank you to Pamela and Omar for facilitating this webinar. I am going to copy the link to the evaluation survey in the chat box. So I have just sent it out. I will also be emailing this survey link to each of you today. Please do fill out this evaluation form because it really does help CCMW learn more about the work that we do and how to better ourselves and improve. So thank you again to each of you. Our next webinar is scheduled for next Tuesday at 1:00 p.m. Eastern Standard Time. If you have any questions, please do email me at projects@ccmw.com. Please join our mailing list. Thank you, Pam, for this slide. It shows that we have 2 upcoming webinars happening next Tuesday and the Tuesday after that. If anybody has any questions, let us know.
And
yeah.
I misspoke. So next week is not inheritance. Next week is divorce. And then the final webinar is on inheritance. So we'll get to both of those in the next couple of weeks.
Great. So thank you all for participating in this webinar. This is the 5th of a 7-part series. We're looking forward to uploading the recording on CCMW's website and continuing on. So thank you all.
Thanks, everybody.
Thank you all.